Welcome back, everyone. Thank you for being here today. For those of you who've been since the morning, thank you for being here all day. For those of you just joining us, you're in for a huge treat right now. This is a panel we do pretty much every year, and it's different every year because of privacy changes. And it's become, of course, much more global. So we're going to cover U.S. privacy state, U.S. privacy federal, international. We're going to teach you all kinds of best practices. So in order to teach best practices, we've got to have the best practitioners. So first off, we have Amelia Gerlicher of Perkins, Perkins Coie, and her bio will tell you that she focuses her practice in the area of privacy and data security, counseling clients on preparing and reacting to cyber attacks, as well as managing privacy-related litigation matters, including those arising from a variety of online activity under the Federal Wiretap Act, the Stored Communications Act, the Computer Fraud and Abuse Act, and state privacy laws. It's an incredible amount of laws that you have to be an expert in order to counsel in this area. But what you might miss from Amelia's bio is that she's also has a heart of gold. In pro bono matters, she has assisted a nonprofit in developing resources to educate victims of non-consensual pornography on their legal options, represented immigrants seeking asylum before the immigration court and the Ninth Circuit, and served as counsel for 30,000 Arizona prisoners in a class action case against the state of Arizona seeking constitutional medical care and conditions of confinement. And that she's a real crackerjack with a truly global practice, and I would call her the Katniss Everdeen of incident response, and we're thrilled to have her here on this panel. So welcome, Amelia.
Thank you, John.
And next up, moderating, really one of the best moderators we have, and she's got some of the strongest international credentials of anyone speaking today as well, and that's Natasha Kohne at Akin Gump. It's not just that Natasha is the global leader of Akin's technology, artificial intelligence, and machine learning and cybersecurity, privacy and data protection practices. So that's a big area. And she works out of both their San Fran and Abu Dhabi offices, having spent all of her 20 years at Akin Gump climbing the ranks. But it's also that she served as an international arbitrator for disputes before an array of courts and international tribunals in the Middle East, Europe, and North America. And if you can, I suggest you go to YouTube, watch the IR forum on ransomware, where this is one of the rarest times you will see that an incredible interview with the OFAC Assistant Director of Enforcement by Natasha. It's on the securities docket. She's very modest about it, but the reality is her first question out of the box, what was the impetus of Treasury's second OFAC advisory? And it's very rare. In fact, I don't think you could find anywhere on the internet to hear OFAC people talking about this. She's comfortable in any country where a data security incident arises. She is, and I can't help myself here, Natasha. See, she's the Natasha Romanoff of incident response. So it's so great to have her here today. So welcome, Natasha.
Thanks, John.
And next up is Matt Reid. And Matt is managing director and head of the LA office of Abernathy McGregor. And Matt brings deep experience in corporate communications, public affairs, crisis management to provide strategic counsel to clients facing these bet the company opportunities and threats. And this is an area that has really developed over the last few years. And there are very few people who can do it well. And Matt happens to be one of them. And that's counsel during this kind of crisis. If you're a public company, it could mean investor relations. A private company, it can be vendor relations. There's so many dynamics to it. He's managing director at H Advisors Abernathy, where he leads the firm's cybersecurity and litigation practice areas. He's managed the communications efforts for dozens of breaches, ransomware attacks. And we were just discussing this before the break. When do you make these disclosures? How do you make them? There are no right answers here. You just have to be Kennedy-esque and make sure you have someone like Matt Reid sitting at the table. When he's not helping companies managing cyber or other crises, he also dedicates his time to serving on the board and marketing efforts for Alzheimer's Los Angeles, the largest Alzheimer's care organization in Southern California. My dad always told me that one amazing path to take in life is learn, earn, return. And he's showing us just how to do this, which to me makes him, and this may be overstatement, the Bill Gates of IR, at least in my book. So welcome, Matt.
Thanks, John.
Sure. Next up is William Ridgway of Skadden. Per his bio, you'll learn that Bill Ridgway is a partner at Skadden Arps who specializes in cyber, but he's really a jack of all trades, and sometimes you'll find this in IR lawyers. Here's why. First off, Bill was the deputy chief of the National Security and Cybercrime Section in the Northern District of Illinois, where he oversaw and managed all of the office's cybercrime, data breach, intellectual property cases. He also held the positions of National Security Cyber Specialist, Computer Hacking and Intellectual Property Coordinator, the CHIP. You've heard that credential a few times today, and Digital Currency Coordinator, handling crypto-related matters. So he's also taught cybercrime for the last decade at the University of Chicago and argued a number of cases of appeal between the Seventh and Second Circuits. Typical of your IR person, they're not going to hand over the appeal to someone else with respect to their clients. They're going to do it themselves. He's also had other appeals, national security, First Amendment. And when he was a prosecutor, Bill's cases included the successful prosecution of the notorious Null Crew, a group of computer actors who carried a series of cyber attacks in the United States and publicized those attacks on Twitter. Bill's the real deal. He's the Jack McCoy of incident response. So happy to have you here, Bill.
Thanks, John.
And finally, we have Aravind Swaminathan, who's a real veteran of the IR Forum Masterclass. I don't know we've ever had a year where Aravind wasn't on a panel. He's global co-chair of Orrick's Cyber Privacy and Data Innovation Team, which is just massive, covers a lot of ground, a lot of places. What makes Aravind perfect for this panel, is not just that he's an IR expert and through and through, having personally directed more than 200 cybersecurity incidents and data breach investigations, including enterprise network intrusions, cyber attacks with national security implications, which is very complicated. But what sets Aravind apart from most of us is that he cut his teeth as one of the few truly bona fide cyber federal prosecutors, a real trial lawyer, as an AUSA, and as a member of the elite squad of DOJ's computer hacking and intellectual property section. So his mantra about creating a sophisticated cybersecurity preparedness program, which I heard firsthand on one of his videos, begins with this notion. We work backwards. We try to think about what's going to happen and how do we prepare you for that today, with creativity stemming from white-collar lawyers, employment lawyers, antitrust lawyers who solve problems in a crisis above all. I like the way he put that, because there are so many lawyers today that you'll meet who are so dynamic in their practice, because otherwise you can't be successful. It's like watching your videos. It makes me want you to be president or at least attorney general. And I think anybody else who watches it is going to feel the same. So I think, again, so welcome, Aravind, again. Nice to see you, my friend. And Natasha, take over from here. Can't wait to watch what you guys have to go.
Thanks again, John. Thanks for that nice introduction. And it's really a pleasure to be moderating this panel with such a broad range of perspectives. As you heard, we have communications professionals, white-collar lawyers, litigators with an emphasis on data privacy and cyber. And today we're focused on best practices when enduring a cyber attack and post-cyber attack, with an emphasis on data privacy compliance. So with what seems like a constant barrage of data privacy laws, new ones coming out, cyber rules coming out, we'll try to tackle the latest and best practices based on some of these SEC enforcement actions that have come out. When we're dealing with multi-jurisdictional disclosure requirements, whether these more prescriptive rules coming out are even helpful in mitigating cyber attacks, and how to protect companies when they're creating roadmaps, since documenting compliance has become even more important with a lot of these rules coming out. And then I think we're going to go bold and give you some of our predictions on whether the federal government will jump in and save us from this patchwork of data privacy laws. So some of the panels may have touched on the latest SEC enforcement actions and the aggressive posture that the SEC is taking with respect to inadequate disclosure controls and addressing incomplete or misleading disclosures, including in the cyber context. We saw this last month with the Blackbaud enforcement case. We've seen a combination of these issues addressed in the First American Corporation case, the Pearson and Activision case. So why don't we start with our veteran, Aravind? Why don't you kick us off, and with the SEC's focus on inadequate disclosure controls, failure to report up to senior management, just to give you an example, and the focus on the content of these disclosures, whether it's just on a company website or in public filings. What are some of the data privacy lessons that come out of these enforcement actions and some of the best practices we can draw upon?
Yeah, it's a good question. I think what I would say is that
What's different is that it's not just about the privacy aspect of it. I actually think that's the most important piece, right? Like when we think about what's material and what's not material, what needs to be disclosed, what doesn't need to be disclosed, the thing that's most interesting, and Matt probably has got a good view on this as well, is it's heavily qualitative, and it is a significant focus on what is the impact to your brand and your reputation and your ongoing business. So certainly privacy has a big part of that, right? Certainly the more number of people are impacted, it's going to have a larger blast radius. The size of the incident may appear larger, but at the end of the day, what really seems to matter most, in addition to sort of like the numbers of people that may be implicated, is really how does that impact brand and reputation? And so what's interesting is sometimes small incidents that don't have a lot of impact on individuals can have a large impact on your brand and reputation if they cause outages, if they cause business interruption, if they are impactful for the actual service that you provide, right? If you're a security company and you have a hack. So I think those are the really interesting things to me. I think what's interesting is that it's not just focused singly, just solely on the notion of like how many people were affected, what information was affected, right? I think certainly there's a really big part of it, but I think what we're seeing is like a sort of transcending from that as being one of the many proxies for how does this affect our brand and reputation? Like, how are we going to be seen in the marketplace going forward?
Yeah, I think it's a good observation. I think we're also seeing that in a lot of data breach litigation, for example. It's not, just doesn't have to have millions and millions of personal information and super sensitive information. People are definitely getting sued even for the small breaches. Bill, what do you think about what Aravind said, or what are you seeing in this context?
Yeah, certainly, as Aravind mentioned, companies now are thinking about disclosure a bit differently. There's certainly, historically, it was much more focused on the financial impact, and now that's different. The other place where I see a lot of activity on the SEC front is really focused on those disclosure controls, the information flow that's making its way to the disclosure committee. And that's not just, and we've seen these enforcement actions, IT making, management and the disclosure committee aware of these issues. We're seeing even the SEC digging in on your technical controls and saying, you did not patch something adequately. You did not follow up on the security alert. And therefore, you had an inadequate disclosure control because that information actually should have been escalated to IT and then to the disclosure committee. So it's an interesting development where under the auspices of disclosure controls, you're seeing the SEC and frankly other regulators really dig in on the technical side of things in ways that I don't think we necessarily have seen, at least in the past. And so that's something that we're certainly encouraging public companies to be thoughtful of. It's not just the disclosure committee. It's not just that breach materiality analysis. SEC is bringing enforcement actions where there was literally not a material incident, but they're saying even still, you had inadequate disclosure controls to have made that assessment. And so you really need to think forward, even at those small incidents, is that information making its way to the disclosure committee?
Yeah. I think that's right. I think there was probably discussion earlier in some of the panels about how the emphasis on technical is making us all work much more closely together with information security and communications and legal, making sure there's sort of that tight-knit circle. So speaking of communications and that communications perspective, Matt, why don't you tell us a little bit about the lessons companies can learn about data privacy that really just sort of make your job a little bit easier?
Yeah, absolutely. Well, first, I'll just say, Bill and Aravind both call out the fact that this increased regulatory scrutiny, SEC, but it goes obviously well beyond that, places a premium on how do companies communicate through these incidents. And there's some basic ground rules that I think are extremely important as you get ready for what unfortunately has become almost an inevitable event. So having the right team in place, your outside counsel, your outside forensics, communications, your management team, your IT team, having that group together and understanding that communications is really a function of that entire group. It's not just the communications team. And Blackbaud, I think, really highlighted ensuring that the right protocols and structure is in place for communications to flow within an organization, especially during an event. So, when an event happens, what you don't know, is much more significant than what you do at the very beginning. as that changes, as new developments happen, as you're able to confirm information, it's vital that that information is shared throughout that working group and that people understand what is the current state of play. The other is, as you communicate, Aravind raised the great point that reputation is crucial in these events. And so maintaining your relationships with your customers, with your stakeholders is vital. And part of that means taking the information direct to them when you have it. And, delaying damages those relationships, damages your reputation. It makes it appear that you don't have the situation under control or that you're trying to hide it. And then the last thing in terms of best practices that I think is crucial is that you need to make sure that when you do go out with information, that it is information that you can stand by and you can confirm. Because the single worst thing you can do in an event is actually share information and then later have to walk that back. And I think if you look at Blackbaud, it's kind of a great example of how things can go wrong. From the initial discovery of the ransomware attack to them notifying their customers, there was a 2-month gap. What they shared then, they later discovered wasn't entirely accurate. They had to walk it back. There weren't those kind of clear protocols in place for information sharing internally, which led to inaccurate disclosures with the SEC. So it was kind of one thing, on top of another that led to the SEC action that we just recently saw. So it's a good example of making sure that all those structures are in place so that when you are ready to communicate, you're going to the right people with the right information and that the right folks internally know what's happening.
And to pick up on that point and tie it to something Aravind said too, the thing that struck me about Blackbaud was that the information that they said that they hadn't disclosed was information that the incident responders almost certainly understood, but it was probably an assumption on their part. And then the people who were trying to make the most positive connection with their customers and were inclined to minimize on that front, and no one and that connection didn't get made or clarified between the two.
Well, no, that was all. I mean, I don't know how many of you dealt with that, but that was our experience in dealing with Blackbaud. It was, I mean, Matt, to your point, it was a communications mess. Nobody got clear, concise, accurate information. But Matt, can I just turn what you said upside down for a second? Here's the thing I think that we're struggling with. If we have an incident and we determine it's material and we determine that we have to disclose it, that becomes the primary driver of your entire communication strategy, it feels like. Right? It feels like that has the forcing function to say, now you're going to need to do something. It's not bespoke. It's not, like one-to-one. It's a really broad distributed communication with oftentimes, to your point, like we haven't done all that work, right? We know that the impact is going to be large enough that we have to make a disclosure. So now we've got 4 days under the proposed rules. We make the disclosure in 4 days. We don't have a lot of those communications tools. And I think, Matt, the thing that I think we have struggled with working with the comms folks and the brand and reputational folks the most is when that forcing function is activated, how do you meet that challenge, right, of sort of holding those principles that you talk about in like sort of your communications principles, holding those like as the central focus, keeping your customer or your client as your North Star, and yet you have to do this thing that's a blast to everybody. And so I've struggled, like I think that has been the most difficult struggle.
It's an incredible struggle and tension about how do you do that. We had a client a few years ago. It was a cybersecurity company that itself had suffered a breach that triggered GDPR notification requirements. So we had 72 hours in that situation before the data protection authorities needed to be notified. Because it was a security company, and because the CEO was adamant that he was not going to make regulatory notifications and not at the same time go out and talk directly to his customers, we had 72 hours to put together the full outbound communications program. I will say that was a really good example of how this can work. in a compressed time frame. We were out, we had to train customer facing teams. We had to have the full messaging available. There was so much that we didn't know but we were still going to go out and communicate to everybody. We knew it was newsworthy because just the irony of a cybersecurity company itself being breached. So we had to be ready to have those conversations with the media. What was striking to me in that situation was the fact that at the CEO's direction, putting customers first. So the notifications happened, then going out to those customers, even though we couldn't answer all of their questions, they were grateful that the company was taking that step. And it actually solidified the company's relationship with its customers. In fact, in many cases, customers were apologizing to the company for having to go through this. So it was remarkable. I will say on the media side, we were treated very fairly, but the media, they're not going to give you the benefit of the doubt the way customers do, that you're taking that step, 72 hours or 4 days into an event. They still want all the same questions answered. In that instance, you're not able to answer every detail that they want, like how and when and how many and exactly what was what data was impacted. But in the end, I think that it just crystallizes kind of your point, Aravind, that sometimes you are the timeline is thrust on you. But even in those situations, I think it's possible to get out and do it effectively and do it in a way that really does secure reputation and stakeholder relationships.
Yeah, and I think we're all getting used to coming out sooner without full information. The rules are forcing us to, but also I think our customers are forcing us to as well. So definitely the trend towards kind of saying something sooner rather than later is already with us. I see a bunch of really good questions in the chat. I think I'm going to ask one of them in a moment, but before I do that, Bill, why don't we turn to you and turn to investigative trends? What the regulators are really honing in on these days, especially as it relates to data privacy. What are you seeing?
Sure. So kind of outside of the SEC realm, of course, there's a lot of other activity. Three trends that I think are notable. Obviously, one of them is a lot of these enforcement actions we're seeing now are not from a breach. There is actually no exposure of data that has been, happened. That was, traditionally that was the way that those tended to happen. And so we're seeing a lot of, situations where a security researcher finds a vulnerability, reports it, and suddenly that's the basis for an action. And even we tend to focus on the states that have been adopting these data minimization rules. My experience, at least, a lot of the regulators, even if they don't have that regime, have like a presumption that if you have data that's sensitive and you don't have a very good reason for maintaining it, the presumption is you should have not had it. And so you may say, well, you didn't clearly say that in your laws. And they say, well, we have this, unfair practices regime. And so they're really, I wouldn't just look at the states that have the data minimization rules. I think it's broader than that. Second big thing that we're seeing for the non-breach incidents is we're seeing a higher use of whistleblowers on the part of investigators. So we're seeing a lot of IT, cybersecurity, privacy-oriented whistleblowers. And so what we tell organizations, in the white collar space, we've gotten kind of used to that. Like we have protocols for reporting fraud and how to try to handle whistleblowers internally. And you need to take some of that learning and apply to the data privacy and cybersecurity space, because the best thing you can do is hopefully respond to the report before it gets to the regulator, because that's usually not a great result for the company. And the third thing is we're seeing pretty aggressive positions taken by state AGs on data breach notification rules in situations where, I think the laws are rather vague. Just to give a concrete example, New York AG has been pretty aggressive on the credential stuffing regimes where it's, someone takes a password they've stolen from somebody else, not your client, and they use it to access a customer account. It's a little unclear whether that's a breach of your client in that situation. And yet the New York AG has certainly taken the position that customers need to have received notice in that circumstance. So where there's some close calls, and maybe traditionally companies were able to rely on judgment in making those calls, I think those judgments are being second guessed, which creates more of a desire to kind of err on the side of notice in those areas.
All right. Yeah, I think it's also good to know which AGs, sort of move in one direction versus another, what they, their tendencies are. So, and I think you answered a question in the chat. Maybe you can repeat it. The question is whether organizations are required to investigate potential privacy incidents reported where no data exposure has actually happened. I think you referenced that in the first part of what you said.
Yeah, I think it's, I mean, I don't know that all companies do, but I do think it's actually worth, looking into, because those are sources of exposure for companies. And there's been just a number of enforcement actions we all have seen that involve just the exposure where there's really no evidence that anyone actually exploited the vulnerability. So those are worth, I think, looking into. I mean, obviously there's going to be severity levels. We have to be realistic, but we should not lose. You can't just say, the tree falls in the forest and didn't make a sound. It makes a sound to the regulator if it gets into their hands. So keep that in mind.
Yep. All right. I think we're going to move a bit just briefly to, issues around multi-jurisdictional disclosure obligations. I think, U.S. regulators at the federal and state levels have been proposing more and more of these prescriptive cyber regulations. And it's always been a dilemma. How do you deal with the GDPR 72-hour requirement with the state data breach notification requirements that range from, generally 30 to 45 days. And then we continue to add layers of notification obligations. We've already mentioned the SEC cybersecurity proposed rules for public companies where we have notifications within 4 business days. And we'll see if that changes. So Amelia, why don't we start with you? What are some of the recent best practices around handling these different layers of notification obligations and level of specificity to be provided in these notices, especially given the scrutiny that we're seeing, some of the regulators provide in these enforcement actions?
Sure. I think, all of this just underlines that preparation is really critical and can take some of the pressure off in some of these situations. In these cases, you've got all the normal planning issues we've talked about, the fact that, legal and communications and IT should all be talking carefully, making sure that these things are reported promptly so you can have these discussions. And knowing how to do that ahead of time obviously makes all of that happen faster. But specific to kind of these issues, doing that jurisdictional analysis for your company ahead of time narrows down the options once you get there, right? Knowing whether you're subject to the laws in, Thailand or Costa Rica or GDPR or whatever should be done ahead of time. I shouldn't be asking that question of my client. Are you covered by GDPR? Getting because that puts you certainly on your back foot. And then deciding once you figure that out, there's going to be countries where you want to take kind of a toe the line and you're already talking to the regulator and you need to take perfect compliance. And there's going to be countries where perfect compliance is not something that you can do. But again, something you should know ahead of time. You should also understand which ones are places where you can submit kind of partial information and it's not public. And as for something like, say, submitting under GDPR, as much as we worry about the 72 hours, in most jurisdictions, you can submit those notices and they can be pretty partial and it's not going to be public and you can do that and continue with your investigation. That's not what the SEC, for example, is contemplating. And so that's just a much different way of kind of ordering your communications. And then thinking about how your legal and other teams are structured so that you've got kind of one central way of constructing the narrative and sending it out to the different ways in which you can do notice, because it's tempting to kind of delegate to your different international divisions if you need to, but you can't have them all writing narratives and submitting them separately. That's just going to get you into a world of hurt down the road.
Yeah, Aravind, you want to say something?
Yeah, so I think everything Amelia said is exactly right. I would just add 2 things I think that she kind of touched on, but I'll just highlight them, which is I think you have to have a lowest common denominator approach, right? Because there's a real need not to treat your stakeholder base disparately, right? So we're oftentimes saying, okay, if you're going to have to notify in any significant jurisdiction with any significant volume, you really need to think about, okay, that's the trigger and it just triggers everybody else, right? And being able to do that quickly is hard to do. So oftentimes we're looking at the lowest common denominator because we want to treat our customer base, our employees, all equally, right? Whether they live in Bulgaria or they live in South Africa or they live in wherever, right? And so I think looking at that is really important. And then I think we layer onto that, right? What is your North Star in that conversation, right? Because at the end of the day, I think it's a really lousy thing to come out and say, well, we didn't notify you because we didn't have to, or we had time to notify you and so we waited, right? And so I think moving with the deliberate speed that you can, understanding that you need to be able to provide useful information, meaning actionable information to the people you're notifying. Don't just tell them there's a problem. Tell there's a problem and how much they have to worry about it or where they don't have to worry about it, and tell them what they need to do. That type of action, right, in your notices is actually more important. And it's where you gain trust, not lose it. So like in the ones that you probably talked about, is like, my guess is when your client in that security context was saying, here's what's happened, they were giving them things that they could do. This is where our device is vulnerable. Here's how you fix it. Here's why we want you to fix it. Here's what the risks are. That empowers them to act in a different way. And I think if you level set on the most important thing is customer trust, because at the end of the day, like, look, will a regulator get upset if I didn't go fast enough? Yes. Do they always get upset? Yes. And so like, that's not the thing I worry about, because regulatory enforcement actions, like, we can manage those. What I can't manage is when my customers are like, not doing business with you because we felt like we were deceived. We feel like you didn't trust us. We felt like you didn't treat us with the respect that we have earned, having been your loyal customer, your partner, whatever it is, for the last however many years. So I think Amelia's right in all of the things she said. I'd layer on, as we think about what our strategy is, those two guiding principles, I think, really ultimately end up being the drivers for how you decide and when you decide to notify.
Yeah, and I think that you mentioned already that your anecdote about the time when you really had to push out all these different notifications within the 72 hours they wanted to notify everyone. So any other thoughts on that experience, or how to really manage what you're really saying very early on when you don't know much and you actually do need to notify people earlier on than others?
Yeah, absolutely. Well, I think there's two things that from the comments from Amelia and from Aravind that are crucial here. The first is the consistency of the message. And Amelia, I think you hit the nail on the head there, that you want to make sure that what you're communicating, one, you want control over it because you want to make sure what you're saying is 100% accurate. You don't want people freelancing and suddenly sharing information that you're going to have to go back and course correct later. So having that kind of central kind of book of this is what we know and this is what we can say. And Arvind's right. You don't want it to just be, we found a problem. It's got to be some proactive steps that you can demonstrate you have control and that your customers can understand what they need to do. So those are important. The other thing I think that is crucial is, there are the regulatory deadlines that we are all kind of talking about that dictate a lot of what we're doing. But there's also kind of a reputation clock that is important for companies to recognize. So even if they do have a longer window, taking it doesn't necessarily, and in fact usually doesn't, maintain those important customer relationships that are so crucial. So operating with all due speed, even if you don't have a regulatory deadline that you're trying to meet, is going to be important in that kind of reputation and stakeholder relationship that these companies need to have top of mind, at the same time that they're keeping all their notification and legal requirements top of mind as well.
Yeah, I think to Arvind's point too, those are often two separate conversations. Like the customer, how we're going to deal with that, how broad we're going to go there is one set of notifications, and kind of your regulatory can be a little different and narrower. And the more time you've taken ahead of time to think about what that looks like, the more time you can figure out focus on the communications that matter, going out to your customers after the fact.
Yeah, and while we're still on a lot of these topics on multi-jurisdictional, different layers and notifications, we do have a question that's a pretty good one. This is in relation to the SEC cybersecurity timeline of reporting material breaches of within 4 days, which is our favorite topic. And the question is, what do we recommend as a timeline to have third parties notify your company of breaches involving data? And obviously, ideally it would be ASAP, but not always feasible. And if the 4 days is triggered by a materiality determination, what does, if a third party doesn't inform your client for weeks, would the SEC take action? So we've got that in our Q&A. Who wants to tackle that one? Bill, what do you think?
Sure. I mean, so I guess in most circumstances, I think more about wanting to know about the incident for your protecting your own company and less about the SEC. But let's put it on the SEC. I do think the SEC would expect some sort of timeline required, such that it's not going to be a great excuse to say, well, we didn't have it. They weren't required to tell us it. We didn't find out till 3 weeks later, and therefore the investing public was misled. I don't think that's a great narrative to have. So we do think, I think as a practical matter, it's good to have some sort of timeline in those notifications. I don't think I know a lot of them say immediately. I kind of feel like that's a little bit ridiculous, and it just means they're going to be in breach no matter what. So that's just contracting gone awry in my mind. But so I do think there should be a timeline. There is an aspect though, and we talked earlier before this. Just being aware of an incident without knowing a lot of the underlying facts is not actually going to help you all that much. And so it's more having good partners who will actually get you the information when you need it. And hopefully you're having to rely less on a contractual requirement, because if you're having to rely on that, it usually means everyone's going to be having a big problem overall. So that's, I guess it's a long way of answering that question.
Yeah, all good points, I think. And not an easy question to tackle. So, okay, we're going to go privacy compliance post-incident. The incident is over, notifications are out. You're conducting a post-mortem. What are some of the most effective data privacy practices that could help mitigate cyber attacks in the future? What are you seeing companies starting to tackle? Aravind, why don't you tackle this one?
So, I think we go back to oftentimes the very basics in terms of information governance, right? Like the obligation to notify individuals becomes because you lost their data, right? So if you don't have their data, you can't lose it, and you don't have to notify them. So we oftentimes, I cannot think of an incident where we didn't sit back and say, wow, do we really need this anymore? What value is it to us? Why do we have it, right? And then I think you take a step forward. So I think you think about whether you need the information, whether you're keeping it, why are you keeping it, are you using it? And then we start to talk about protection measures, right? Because the easiest thing to do is just blow it away, right? And we had an incident where they stole terabytes of data. A huge part of what they stole was literally, think about this as a hospitality industry. They stole the menus from dinners for 10 years. We're like, great, you can have all those. But the point was we had to sift through all those to get to that point. And that was just a waste of time and effort, right? And consternation. So we're not just, when we think about information governance and retention, we're not just thinking about personal information, we're thinking about all of it, right? And so we start with basic principles of information governance, and then we think about controls, right? And only protecting what you have because you need to have it. And so I think if we think about it from a compliance perspective post-breach, that's almost always where we start, right? And then we start to go down the road of some of the things that Amelia was talking about, which is okay, if we're going to keep this, what is our risk if we lose it, right? And understanding that a little bit more of what that triggers, and then taking a little bit more of a granular or balkanized approach to what data we have and why do we have it, and those sorts of things. Do we really need to keep this biometric information any longer, right? And so that's a lot of where we go. So we start with sort of those basic principles.
Yeah, Bill, anything to add to this one?
Yeah, whenever I hear the term post-mortem, I always get very scared as the litigator. It usually is not the ideal thing to be documenting, but you have to do it. And Arvind's right about the practices. Two thoughts, just things or trends we're seeing. We're seeing these be more often instituted by a board or a subcommittee within the board to have a little bit more of a separation from there's a little bit of like business, rivalries that can happen when you talk about data and what needs to be retained and what doesn't. And so sometimes we see separation through governance to help that. And then look, that it's not always possible, but trying to have this through the lens of a privileged lens can, that's something that's at least worth thinking about as you think about designing some of these, if you're really going to have to go through and make an assessment along those lines.
Yeah, and it's also might be worth noting that, if a company experiences a data breach here in California, where I'm sitting, and you're forced to notify the California Attorney General, what we're hearing on the ground is the California Attorney General will use that opportunity to start investigating your privacy practices. So even though sometimes people separate the two, and the CCPA violation is not the same thing as experiencing a data breach, it is one of those situations where you obviously would want to be concentrating on both, and that's basically what we're hearing on the ground here. So moving to proactive measures, Matt, I think if you can tell us some of the data privacy steps companies can take to mitigate a front page data breach, please do. I think a lot of clients and contacts, they sort of accept that a data breach is going to happen, a security incident is going to happen, but what they're preparing for is trying to avoid waking up to that front page news. So tell us a little bit about that.
Sure. I think the biggest and most important step that any company can take, one is having a solid plan in place. The goal is, if in most cases this is going to happen, so how do you ensure that you have a bit of a running start and you're not flat-footed? So have a plan in place, have your team in place, both inside and outside, and that you're training on it. And that enables you to move as quickly and effectively as possible in an event, which helps you kind of keep it, hopefully off the front page. The second, and there, we have a recent client was involved in a breach. They are a third-party administrator, and they work with state and local government agencies and corporate clients through multiple states throughout the U.S. And in the course of the communications around that situation, we were assisting with, or in some cases, taking care of notification requirements for their customers across the states. And it provided a very interesting approach, because each one of their customers was deciding how they wanted to handle the notification and the communications around it. And what was interesting is the customers who really wanted to focus on direct communications to their end users, and a strong narrative, and trying to put that stakeholder first approach. In many cases, they were going direct to their customers. They were using, where needed for the public notification. They were doing public notice ads, and they were able to really effectively control that and maintain that narrative. In other instances, the end customers to notify, they were taking a much more broadcast approach, issuing press releases, maybe putting a little less emphasis on the getting as direct to their customers as quickly as possible beyond pure regulatory requirements. And in those instances, you saw the story kind of take a little bit of a life of its own. So I do think it was a really good example of, having the plan in place, having the narrative really set, and then taking it out as proactively and directly as possible was, seeing those side-by-side comparisons, what we saw that was the most effective from a reputation standpoint and in terms of maintaining those relationships.
Right. Well, I think we only have about 6 minutes left, and I do want to get in the predictions from this panel. So, but I want to ask one more question before we get to the predictions of the federal privacy law, proposed privacy law. And that's really about the fact that more cyber and privacy rules are requiring us to run these risk assessments. And we know that they can serve as a roadmap, puts a company on written notice of what its highest priority risks are. And the chances of these risk assessments being protected by the attorney-client privilege is pretty low. So Amelia, tell us a little bit about what companies can do to comply with these privacy laws, conduct these risk assessments, protect the company, but also mitigate the chances of, maybe a plaintiff's lawyer or regulator getting their hands on it to the extent that they don't have to send it to a regulator anyway. But give us some pointers on that.
I mean, I'll start with kind of the theme we've been talking about in terms of getting this right in the first instance. Doing it first is more important than worrying about the privilege issue, because thinking about this all and preparing is in a lot of cases the ball game. And it makes you. I'm reminded of the story about outrunning the bear, right? You don't have to outrun the bear, or you don't have to outrun the bear. You have to outrun your slowest friend. You're making yourself not the lowest hanging fruit. So to the extent that makes you less of a target, that lowers all the rest of the risks we have going on. That said, if you find yourself in that situation, the privilege landscape is very hard. And for proactive things where you haven't actually had an incident already, the landscape's worse. So absolutely do them, get legal counsel in around what it needs to do to satisfy your legal requirements, and to talk and to put the most sensitive discussions around what's been found, what's high risk. Have those discussions with legal about what needs to be fixed. Have a lot of those discussions, orally first before writing them down. Think carefully about what the written report looks like, and know that you're not, what the written report ends up being is more likely to be disclosed to adversaries if you disclose it widely within your organization. So think carefully about who needs to see it and why. And, back to the original point, sometimes that's worth the risk, because the people who need to see it are the ones who need your board, because they need to be able to dedicate resources. That's more important than worrying about the privilege downstream risk in some cases. So to kind of think through what's going on and who needs to see it at each step of the way.
Yeah, I find this to be a very challenging area. So thanks for that. All right, I think we're going to wrap up with the American Data Privacy Protection Act, which was our much anticipated federal bipartisan potential GDPR equivalent. Not quite, but it's been percolating as a draft federal legislation for some time, and it's the closest we've gotten to potentially passing a real data privacy bill at the federal level. So, and in addition to the ADPPA, we have 5 comprehensive state data privacy laws. We now have 2 more, Iowa and Indiana, and maybe Montana. So the states are continuing to roll out these state privacy laws. And honestly, the differences between them are enough to create compliance challenges and headaches. So as we sit here today with 7 or 8 comprehensive data privacy laws, what is your prediction about the passage of the ADPPA? So, Bill.
I would be reluctant to suppose that it would actually be passed, given how much this conversation. I think we probably had this every year for the last 10 years, and seemed never to come to pass. So that's my vote.
A good bet, Aravind.
Not in my lifetime. It's just, we've been talking about this for 20 years, not in my lifetime.
Interesting. Amelia.
I would say it isn't necessarily what we want. We talk a lot about oh my God, there's 50 different breach notification laws, or maybe we talked about this, more before there were 100 different country laws, but it doesn't make things easier. It just is going to be another layer of obnoxious compliance I'm sorry, did I say obnoxious? Another layer of compliance if we do get it, although I'm not going to lay odds on that.
Yeah, Matt.
Yeah, I don't see it.
All right. Well, thanks for that. I know it's hard to go out on a limb. I know in California, we fought very hard to keep the CCPA, but the draft bill has definitely gutted it, which is probably good news depending on what side you're on. So with that, thank you all. Really insightful comments. A few of you got a shout out on the chat. So good job. And thank you, Bruce.
Thank you, Natasha and Matt, Bill, Aravind, Amelia. Thank you all very much for your insights and a really great panel. We really appreciate it.